Assalamu alaikum, sir. This is MD Moshiur Rahman from 10th semester, Department of Law, American International University, Bangladesh. Today we will discuss about the summary trial of criminal proceeding throughout the whole presentation. We will divide our topic into various parts of our discussion and we will try to give a better understanding about summary trial. In my part of presentation, I will discuss about the definition and the purpose of summary trial. After me, my group mates Anjina-e-Noor Ava talk about the power to try summary trial and which offences can be tried in summary trial. In third, Tanjim Al Mahmud talk about the procedure for summary trial, and finally, Abdul Latif Jamil will talk about records and judgment in summary trial and the difference between summary trial and the regular trial with his concluding remarks. So we will go through our main topics. So what is the summary trial? Summary trial is the trial where a case is disposed of speedily and with the procedure is simplified and the recording of such trial is done summarily. On the other hand, which offences are sentenced or not sentenced to not exceeding 2 years, those types of offenses can be tried in summary trial. In summary trial, only small cases are tried and complicated cases are reversed for warrant trial. What is the purpose behind the summary trial? The main purpose of summary trial is to expeditiously dispose of the cases as the case load on the judiciary is immense and continues to grow. It is also seeks to uphold the legal maxim justice delayed and justice denied. The proceeding is every case have to be done courteously and prudently. A summary trial implies that the case is tried and disposed at once. Such a trial is not available to cases which are complicated and require a lengthy process of inquiry. The access to summary trial allows people to pursue justice even in small cases which would have otherwise taken several years to complete the proceeding. The section 260 to 265 of the Code of Criminal Procedure 1898 deals with the provision related summary trial. That's all from my presentation. Thank you, sir, for listening to me. Assalamu alaikum wa rahmatullah.
Assalamualaikum sir, my name is Anjina-e-Noor Ava. Today my presentation topic is summary trial. In this topic, my parts are power to try summarily and offense which can be tried summarily. So now I am going to present my presentation. Power to try summarily. Section 260 of the Code of Conference, any metropolitan magistrate and magistrate of the first class with the power to try summarily. However, a magistrate of the first class, in order to try summarily, has to take special permission from the High Court. As for Section 261, any High Court may empower any magistrate of the second class to try summarily any offence punishable with fine or imprisonment for the term of exceeding 6 months with or without fine, and any attempt or abatement of such offences which can be tried summarily. Section 261 and 262 provide the case or the type of case which can be heard and tried by first class and second class magistrate representatively. Number 1 is offences which are not punishable with death or imprisonment with life imprisonment for a term of exceeding 2 years. Number 2 is offence relating to theft prescribed under the section 379, 380 and 381 of the Indian Penal Code IPC, where the stolen property is not valuable more than 200 rupees. Number 3 is offences are relating to receiving and retaining any stolen property under section 411 to the IPC, where the value of the property does not exceed 200 rupees, and asserting in the disposal of any stolen property as prescribed under the section 414 of the IPC, where the value of such property does not exceed 200 rupees. And number 5 is offense which are embodied under section 445, 454 and 456 of the IPC. And number 6, a offense relating to insult with intent to provoke of breach of peace under section 504 of IPC. In number 7, the offense as prescribed under the section 506 of the IPC relating criminal indentation punishable with imprisonment for a term which may extend to 2 years or fine or both. And in number 8, any abatement of the in the above mention of offences. In number 9, any attempt to commit the above mentioned offense where the attempt of such offense is punishable. And the last number is number 10, may any offense committed within the meaning of section 20 of the Settled Trespass Act 1871. It is the power of the magistrate to try specific offence in a summary way. Section 260 of the Code only does not empower the magistrate to try such cases which he is not competent to try. It empower him to try the cases that he is already competent to try by a particular procedure. The particular procedure, the subsection 2 of the section 260 provide that any witness can be recalled for examination and reheard when it appears necessary to the magistrate that the case should not be tried summarily. If the mode of the trial is sought to be altered in the midterm in the ground that the offence is such which cannot be tried summarily way, the trial must be conducted in regular manner. Offences to be summarily need not to be punishable under the penal code of a penal code. Offences under special or local act can be tried summarily if they fulfill the condition punished lay down. Thank you for hearing me along. Now I am going to hand over my presentation to my fellow mate Tanjim Al Mahmud. He will going to describe you the another part of this presentation. Thank you.
Assalamualaikum sir, this is Tanjim Al Mahmud from AIUB Department of Law. We are discuss about summary trial. We divided our topic into various parts for discuss. In my part of presentation, I will discuss about summary procedure. After me, my groupmate Abdul, Latif, Jamil will talk about judgment and record and difference between regular trial and summary trial. So let's go in our main talkative topic. The provision of section 262 of code are imperative and a branch thereof amount an illegality and not an irregularity. Section 262 strictly provides that the procedure for summary trial shall be conducted as per the procedure established for conducting the trial of summon case, except otherwise provided. Adherence to this provision has to be done irrespective of the nature of the case, that is whether it is a warrant case or summon case. Further, it prohibited by section 262 of code to pass any sentence or of imprisonment for a term exceeding 3 months for any conviction in respect of summary trial. A sentence exceeding the period fixed by this section is illegal. In the case of Asghar Ali, it was held that the limit of imprisonment refers only to the substantive sentence, not to an alternative sentence of imprisonment in default of a payment of a fine. A magistrate can impose a sentence of imprisonment in default of payment of fine in addition to the maximum sentence of 3 months imprisonment which he has imposed for the offence. The subsection only imposed a limit to as to imprisonment and not as to the amount of fine to be imposed. Thank you for listening to me. Assalamualaikum.
Assalamualaikum. I am MD Abdul Latif Jamil from 10th semester of AIUB Law Department. Today our presentation topic is summary trial. My group member already discussed about offense, procedure and power of summary trial. Now in conclusion, I would like to discuss about records and judgment of summary trial. I also try to give some difference between summary trial and regular trial. According to section 263(8) of Criminal Code, we know that magistrates have to record some particulars. These are serial number of the case, date of the commission of offense, date of the report, name of the complainant, parentage name and address of the accused, value of the property for which offense committed, plea of accused and his examination, the finding, sentence or other final order, and last one is date on which proceeding terminated. The main difference between summary trial and regular trial is summary trial can be concluded only for specified offences which are minor in nature but complicated and serious nature of offense is tried in regular trial. Number 2, in summary trial only the substance of evidence is briefly recorded, but in regular trial evidence is recorded carefully and in full. Number 3 is in summary trial no formal charge is required to be framed, but in regular trial charge sheet is required to be drawn up. Thanks for listening to me.